stating the laws of the state for the Commonwealth. Now, here, your intents, you shall be heard. The Commonwealth of Massachusetts, court is now open. Please be seated.
Good morning. Welcome to the Appeals Court. I am Justice Meade. With me today are Justices Desmond and D'Angelo. We will be the panel for the first 5 cases. We'll take a break after that and reconstitute the panel. Each side gets 15 minutes. You needn't use all of your time. We've read everything. We do not entertain rebuttal. And with that, I'll call our first case, which you both know is impounded. 23P 1031 John Doe 237044 versus the Sex Offender Registry Board. Mr. Burkholder, welcome back.
Thank you. Good morning, Your Honors. May it please the Court, Attorney Fred Burkholder for John Doe 237044. I want to talk about application of Factor 35 in this case. Very interesting case from my perspective for the following reasons. Single isolated offense, 2005. The young man's 12 years old. We can all do the math. It's been 17 years. His history since then has, of course, been not favorable. He's been in and out of institutions. He's been diagnosed with some severe psychological conditions. He's presently held at the Taunton State Hospital. My argument is tailored to some degree from what's written in my brief in response to what my brother wrote. I don't know that consideration of the psychological reports that we both submitted into the evidence, or at least both of our sides did, into the evidence, was inappropriate or error. But what I do think is that they say different than what's necessary to support a finding by substantial evidence that he continues to be low-level risk. My concern is the hearing examiner's statement at the conclusion for consideration of Factor 25 or 35 that says, however, I am not persuaded that he will be as stable outside of a secure setting, thus elevating his risk to reoffend should he be discharged. Now, so the question becomes...
Do you think that has some facial appeal to that finding?
I don't think I understand the question, sir.
Do you think, from a common sense point of view, that finding makes sense?
Yes, but I think you have to look at it a little further, and that's the same error that I want to point out that the Superior Court made when they evaluated this case. They said the evaluative reports and assessments in the record clearly and convincingly relate Doe's mental health as it was asserted at the time of his most recent and continuing hospitalization to his risk to reoffend. So what they're saying is it's relevant. However, my brother did a tremendous job of outlining my argument with regards to why the evidence that's in existence with regards to his mental health no longer basically establishes substantial evidence for a level 1. I want to point out, first of all, his only alleged sexual misconduct between the time of his offense, when he was 12 years old, to the present, my brother says happened twice. I combed this record continuously. I couldn't find 2 allegations. But what I did find was allegations of 1, which Dr. Connolly describes as follows. His recent sexual taunting of a mentally ill woman while he was with other males was not nearly as serious as the gang rape he participated in, but there were certain elements of his behavior that were similar to the earlier sexual offense. He goes on to say he didn't harbor any sexual deviant interests, but stopped well short of ruling that possibility out. So now we're talking about speculation. And that's the only offense that exists between the index offense and presently to suggest that there's any sexual connotation. Is there a risk of decompensation? Is there a risk that if he goes off his meds, he might have issues with regards to violence? Yes, but that's not what our test is here. Our test is whether there's not a risk to sexually reoffend. And I submit that the evidence simply is just not there.
Counsel, would you agree that the examiner took into consideration both expert reports?
Yeah, but the expert reports are from 2005.
Why isn't it still relevant?
Well, they certainly are relevant. But I guess what I want to point to is the reports that are cited thereafter by my brother, and of course in my report, my brief as well, which talk about 2009 onward note, Doe's aggression has subsided since arriving at Taunton Hospital. Despite his assertion that his reluctance to try medication, he said he didn't want to try any additional medication because the medication that he was on was working. There's references to the fact that his relationship with his mother's improved and he's communicating with her. There's also references.
But it's not, but it has improved, but there's still some issues with respect to his relationship with his mom. But let me ask you this question. The
Yes.
hearing examiner said that this is a person who remains institutionalized today, right?
Yes.
The hearing examiner said that his mental health remains an ongoing concern.
That's correct.
You think that's erroneous?
No, it is. But again, I don't think that the focus of this classification is upon his criminal
They gave him a
potential.
level 1, right?
I can't, I'm having trouble hearing you,
Level
sir.
1? Did they declare him a level 1?
Yes. Yes, they declared him a level 1, which is a low risk. My argument is basically it's speculation. When you only have one offense 17 years ago when you're 12 years old, and you've been institutionalized the whole time thereafter, and most recent reports saying he's improving considerably, but most importantly, you don't have any other evidence of sexual misconduct and no evidence of sexual deviancy. I think a finding that says, as it's stated by the hearing examiner, that in essence, I'm not persuaded that he will be stable outside of a secure setting, thus elevating his risk. It's not my job to persuade him. My job is to show this is what the evidence is, and anything past that is speculation. And that's what I'm suggesting that the finding is here, is speculation. There's just not simply enough evidence currently that he has a risk to sexual reoffend. Does he have a risk to reoffend from a criminal component? Certainly that risk is greater because his behavior has continued throughout the various institutions and the like. But even in that regard, he hasn't been criminally charged or convicted since 2012.
Counsel, you said something a little earlier I want to go back to. Assume the same facts, that it's when he's 12 years old was his last sexual conduct.
Yes.
But while he's in the hospital, and I know this isn't the case, but I'm asking a hypothetical, he doesn't commit any further sexual act in the hospital, but he fantasizes about it. Is that something that the...
Without any question it is.
Why?
Because it suggests...
That's still speculation, isn't it?
But it suggests sexual deviance, the existence of sexual deviance. Drawing parallels from cases which you, of course, hear that are from the SDP standpoint, sexually dangerous person standpoint, the case law there allows extrapolation, and what they look at is whether or not there has been, for the most part, they look at whether or not treatment has allowed them to identify the risks that are present, including preoccupations with sex and the like, and to address those.
So none of your
But that's not here.
None of your clients' mental health concerns, which the examiner talks about, you think lead to a likelihood of future harm, of sexual harm.
If I'm standing back here, certainly I might have that suggestion, but that's not what the test is. When I try to get funds for an expert to evaluate, I am stuck with the test which exists in DOE 89230, which says, show me a nexus. That nexus does not exist here. Even the diagnosis that he had back in 2005 was depression and anxiety.
So do you think that, so what do you think it should go back to the hearing examiner so he can explain what the nexus is between his ongoing mental health concerns for this institutionalized person, or what?
Yes.
That's what you think should
Yes. Yes. Well, if there's any further questions.
You don't think that there's enough in the record to support a level 1 absent the consideration of factor 35?
I think it's speculation. I think it's conjecture. I think the case law is very clear. We both cite it. It requires evidence, and especially when you have these facts, an individual committed his offense at such a tender age.
It was a pretty serious offense at such a tender
Without
age.
any question.
Crazy offense.
Without any question. But he was 12 years old. I mean,
I think that cuts both ways.
well, and I'm not saying that the hearing examiner didn't consider him as a juvenile, because that was done. I mean, I give that to the hearing examiner. He properly took a look at it and the like, but we're looking at is present evidence, and when you have that period of time, and the only thing he did was possibly harass a nurse and there's no other sexual component, and the own psychologist says there's no deviancy, and nothing else happens? I mean, if the individual's as bad as we think he is, he should have been doing what most of the guys in this situation are, which is all bad things. He didn't do any of that.
I didn't see that in the record.
Well, it's not in the record, but the point is that it should be there if the risk continues to persist, and it's not in the record. That's my whole argument. It should be there if there were continuing problems with the sexual preoccupation. They didn't even say that his initial offense was based upon psychological. They said it was more based upon anger. Rather than, the one doctor says, I have to find it, but one of the doctors says, well, let's see, I'm going to put my hand on it very quickly, because I know the court has other matters to go on with. Basically, that, let's see, no, that's not it. I think it's in here. Well, I can't find it. It's said in my brief, but basically, in essence, says that the offense was more his attempt to adjust based upon the loss of his father, leaving the family situation and the difficulties that he was having, trying to fit into a group and the like, and it wasn't based upon a psychological component or even a sexual component. It was more anger that manifested itself in that manner. I just think when you're going to continue to label somebody after all this time, you have to look at their behavior. This is my STP appellate mind thinking, and I just don't see it.
Thank you.
Thank you.
Mr. Haynes.
Good morning, Your Honors. James Haynes on behalf of the Board. I will try to be equally succinct. The hearing examiner's decision here was supported by substantial evidence, and the decision to reduce Doe from a 2 down to a 1 was neither error nor abuse of discretion. The record reflects the fact that his index offense, though concededly dated, was violent and it was serious, and then he continues to have a history of behaving violently and engaging in criminality for several years after that, including being adjudicated delinquent for a attempted murder a year after the index offense. All of this is happening against the backdrop of Doe's significant psychiatric history, which my brother alluded to, and you know, that was something that predated the sex offense, and unfortunately for Mr. Doe, it's something that has continued along, and it appears to have gotten worse to the point that he is, you know, presently and has been. He's been civilly committed effectively since 2019. He was at the time.
The crux of the argument seems to me to be that, notwithstanding his mental health concerns and issues, significant mental health issues, that the hearing examiner didn't explicitly say why he believes the ongoing mental health concerns could lead to recidivism.
So I think that the hearing examiner was trying to be somewhat delicate about not drawing a straight line between. It would have been inappropriate for the hearing examiner to say, this person has a psychiatric problem, therefore they are sexually more at risk. What I think she did was try to view the psychiatric history through the lens of our factors and see how it increases some of the risks or inhibits some of the risk mitigation. So you see that in terms of how she's saying, well, he does engage in, when he decompensates, he becomes more violent. He commits violent crimes, so that gets you to factors 10 and 11. It also, it has inhibited his family's ability to provide support for him and keep him on the straight and narrow. That's why she gives less mitigating credit under factor 33. So I think that's, she doesn't specifically say that, you know, a psychiatric problem automatically increases your risk of sex offense, because I don't think our factors would support that. But she does observe that the presence of this thing that was there from the moment he committed the sex offense until January 22nd, when he's having this hearing, it has been the elephant in the room all along, and it has definitely driven him. It's expressed itself in ways that dovetail with our risk elevating factors.
And so you think that the hearing examiner properly applied factor 35?
I do. I think,
What's your
you know,
best case?
well, I think the language of the factor itself is the reason that you can go to there. I mean, it says that she's obliged to consider all of these evaluative reports and see what indications that they may have. And again, you have a history of evaluations that start from prior to the sex offense in March 2005 and carry on all the way essentially to 2012 when you get that mental illness and problematic sexual behavior.
Best case.
Off the top of my head, I don't have one that I could cite to you. Factor 35 is, you know, it's, I don't have a citation. I would just hinge on the language itself directed her as to what to do here, which is look at all of his psychological records and try to figure out how they apply back to the rest of the factors, which is what she did here.
Counsel, you said that looking at the reports and what, quote, indications they may have. Indications they may have to what? I think it's clear based on the reports that because of the mental health concerns, he might be violent. That doesn't necessarily mean it's indicative of sexual recidivism, does it?
It doesn't, although I think several of those reports then draw the further conclusion that his violence often expresses itself in, or has historically expressed itself in sexual misconduct. So, and I think my brother alluded to that during his argument where he said that, you know, they don't find that he has evidence of sex, or they speculate that he may not be behaving due to sexual deviancy, but rather because of anger. But if you look at the reports are replete with concerns about the fact that he has extreme difficulty keeping his anger at bay, that he has anger problems, that he tends to lash out during when he was engaged in sex offender treatment.
Hey, Counsel,
Sure.
Other than it's a big other than the index offense.
Yes.
What other sex misconduct was there?
So there's a sex offender risk evaluation that was done shortly after the index offense. It comes from October of 2005. It's in the first volume. I don't have a citation to the page handy, but if you look for an October 2005 sex offense, it primarily addresses, obviously, the index offense, but it also makes reference to an earlier offense where Doe had engaged in some sort of sexually threatening or at least menacing behavior with a female student at the school. I think she said that he had made some remarks to her and followed her into a bathroom. So you have that predating the index offense. And then...
At the two offenses that counsel, when you...
No, I think the ones that he is alluding to are the ones that come in the 2012 MIPSB report, mental illness, problematic sexual behavior. So after he ends up in Taunton State Hospital in 2011, and it's because he was hospitalized in fall of 2010 for having what was effectively a psychotic break. He has a number of instances with hospital staff where he assaults some of them. He ends up first at Worcester Hospital, and then he goes to Taunton Hospital. If you look in that 2012 report, they refer to two, possibly three separate instances. When he is, I believe, at Worcester Hospital around May of 2011, he writes a letter to a female patient on the co-ed floor saying, hey, why don't you sneak out tonight and meet up with me and we'll have, a little bit of fun. I mean, I don't know that that's sexually inappropriate per se, but it was, they considered it inappropriate in the context of where he was. And then there's a second one where apparently he throws a puzzle piece and it lands in a female patient's cleavage. Neither of those got him flagged for the report. The thing that got the report made is an incident in November of 2011 where he and several of his friends or associates at Taunton State Hospital, because he gets moved from Worcester to Taunton after these incidents because of safety concerns, they surround a female patient And at that point, he begins to address her in rather blunt sexual language, suggesting that she should perform fellatio on him. And that was what got him hit with the MIPSB. You know, the doctor who ordered it said this has factual hallmarks that are similar to the 2005 offense, which was, again, sort of a gang rape situation. And so those are the other sexual misconduct that occurs.
So here we are 10 years later.
Yes. He, conceitedly, from that point, he does not have more sex offenses. He had about 6 years, 5 years, I guess, maybe, in the community. Basically, he's discharged from probation by about 2013. He comes back into the hospital by 2019. That's when he's civilly committed. He was there from the fall of 2018. He does get some credit for that. He gets credit under Factor 29 for that unqualified period when he's out in the community and doesn't sexually reoffend. And then the hearing examiner does what I would suggest is a reasonable compromise for the next 3 or 4 years up until when the hearing happens, which is to say, well, no, he doesn't offend for these next couple of years, but he's in a setting which, while not carceral, is, you know, a locked ward. It's Taunton State Hospital. There's more oversight into what he's doing. His behavior is being monitored more closely, so you don't have that same degree of freedom. He's not operating as much under his own steam when he's not when he's not sexually offending. There are fewer opportunities to do so. I mean, it seems like he was self-isolating even while he was in the hospital. So, you know, I think that the point is well taken that he hasn't had any new instances from the instance in 2012, but on the other hand, he's had fewer opportunities perhaps than a person who had been truly out in the community for 10 years. I don't know if there's anything else that the court has. Otherwise, I'm prepared to stand on my brief.
Thank you. Thank you both.
Thank you very much.
Taken under advisement. The next case is 24P868, Department of Children and Families versus Father. As you all know, this case is impounded, so please do not use names. Mr. Robin.
Members of the panel, may it please the court, my name is Jeremy Robin. I represent the father appellant here. This is a case where a judge made competing findings of unfitness and allowed a child to move with the mother in Michigan. Let me begin with something that's worth emphasizing, which is the constitutional rights that are at stake here, Santosky versus Kramer. That applies to my client to parent his child. And while state intervention is justified in circumstances that we are all aware of, mental health issues, substance abuse issues, domestic violence, we have to be reminded that it needs to be viewed as a last resort and that the family should otherwise, I'm citing from the case of Duquesne versus Sugarman, quote, remain together without the coercive interference of the awesome power of the state. I say that, of course, to remind us all the import of changing the natural order of things, which is that a parent should parent their child. And I must also concede and acknowledge that challenging a trial court's credibility determinations, as we're doing here, is a tall order, hard to achieve. But I think there are at least 3 reasons why it's worthy of consideration with respect to the domestic violence, which is at the heart of this case. One is the DCF scheduled joint visits with the parents, and that sort of flies in the face of concerns, protective concerns for a child with respect to my client. Number 2, the mother had cognitive issues that affected her parenting. 3, the mother was inconsistent in her reporting on the domestic violence.
Counsel, can we separate what I see are 2 issues that you have? One, you say that the judge erred by finding your client unfit, but then at the same time you say the judge also erred by finding mom fit. So can we focus on dad being
Yes.
unfit first?
Yes.
What in the record do you say the judge inappropriately found regarding your client not completing his action plan focusing on domestic violence? Let's start with that.
Right. He did not believe that he was a perpetrator of domestic violence. That's pretty clear. He believed that it was, in fact, the mother that was physically abusive to him. And his position was that in order to enroll in the domestic violence class, it required some level of acknowledgement, which he wasn't able to do. But I think
the judge clearly found that not credible, that dad was not the abuser. Would you agree that the findings, that's what the judge found?
I do agree with that.
So
yes.
why is, based on credibility,
Right.
why is that an abuse of discretion?
I don't think we can separate the testimony of the mother from the father in that context, because the mother, in my view, was not a credible witness. She did have these cognitive issues that affected her parenting, and that's in the record. She gave inconsistent statements. She also made a lot of decisions. She went back to him, she left him.
But that's a judge's role to
I
decide
understand
who's
that.
credible and not credible.
There was also the issue of her disengagement in the types of services that the DCF required for her to effectively parent this child. So in spite of her participation, I think, in 2 or 3 counseling sessions, and she completed a parenting class, and that was the extent of what she did. She conducted some virtual visits, but the judge still, with that part of the record, decided that she was a fit parent. But the focus here, I think, has to be on why the father is not unfit, because the ultimate goal here is to remand this case so that he can challenge custody, visitation, whatever else, in Michigan, because we acknowledge that Michigan has jurisdiction. And if he has this finding of unfitness against him, it certainly compromises his ability to do that. So I think that's the goal. But I do want to talk a little bit about his engagement in services, and I do appreciate that he didn't engage in the domestic violence class to the satisfaction of the DCF, but he did a lot of other things that I think can't be separated from.
You have a best case that says that despite him not engaging in domestic violence classes, where a judge has found he was the perpetrator or the aggressor, that we should ignore that.
No, but custody of Vaughn is the seminal case here that speaks to domestic violence, and domestic violence is a serious concern. There's no question of that. However, he did do a lot of the things that we ask parents to do. I mean, these cases come in, a care and protection is filed, and there are a lot of concerns. And the calculus then becomes, to what extent does a parent improve his or her parenting, for lack of a better word, such that he or she can parent this specific child? And the father here did a lot of things. He engaged in a parenting class, Nurturing Fathers program. He was able to tell the DCF what he learned. And there is case law on that says specifically, it's not just the engagement in the services, it's what did you learn from these services. He established paternity so that he could be the legal father.
When he went to Michigan and brought the mother and the child back,
Yeah.
did he slap her 3 days after she returned back?
Well, I think there were some allegations to that effect.
Sure. And there were also some concerns about the condition of the home. I think he was living with his parents and his siblings and 7 dogs and animal feces and dead mice about the house.
Those were
The house was condemned after they moved.
That's a good question, and those were the concerns when the case first came in. But one of the things he did do was he ensured that his family moved to a more appropriate home. I believe it was in Everett. And so he did acknowledge that that was a concern. And again, I think that the snapshot is, what do things look like when the case comes in, and then what does a parent do during the life of the case? And during the life of this case, he did a lot of the things that we ask parents to do.
So it sounds like the gravamen of your argument is the weight that was assigned to what he did and didn't do, rather than factually.
Somewhat, and I think we're challenging the credibility determinations, and again, I acknowledge that that's a hard thing to do. But here, that's exactly what the judge did. She determined that the mother was credible in spite of many statements, much testimony that, as you read it, it's a bit questionable, some of the things that the mother says. And let's remind ourselves that the case came in due largely to mother's deficiencies. She had inadequate prenatal care, failure to follow the infant's feeding schedule, and limited compliance with the service plan. So again,
But mother would say that was because she was held hostage and didn't have any transportation, wasn't allowed to leave the house, was constantly being watched by the father and his family. Isn't there record support beyond what she says, just the police contact when they stopped her at South Station and found the child with the sister and the father in the car? And so wasn't some of what Mom said supported by other facts?
Yes, I think a credibility determination doesn't mean one person's 100% right and another person's 100% wrong. But to say that she had no ability to contact anyone, I mean, the DCF had eyes and ears on this case. They were providing services, and if it would seem to me, if they saw any sources of concern, they would have acted. But, the mother didn't seek a restraining order when she could have, and then she kind of said different things. So if there are no other questions, I'll stop there. Thank you very much.
Thank you. Mr. Salcido.
May it please the Court, Richard Salcedo for the Department of Children and Families. The Department is asking this Court to affirm the trial court's decision finding father unfit and granting custody of the subject child to mother. In making its determination, the Court made 146 subsidiary findings of fact. Those findings are amply supported by the record, and taken together, they clearly and convincingly support the Court's conclusions. Evidence of father's unfitness in this case was overwhelming. The Court found that father subjected mother to verbal, emotional, and physical abuse, including while mother was pregnant with the subject child. He also engaged, as was mentioned, I believe Justice Desmond mentioned, that he engaged in controlling behavior, that mother had no access or limited access to a telephone, had no access to a car, had to rely on the paternal grandfather and father for transportation, and she missed some important medical appointments, including prenatal appointments. In addition to the abuse that she suffered from father, she suffered abuse by other members of the family, including the paternal grandparents and one of father's siblings, a sister who was a teenager at the time. And father was aware and observed a number of these incidents and did nothing to intervene to protect mother. As was mentioned as well, the child was living first 3 or 4 months before removal in an unsanitary home. There were 7 dogs in the home. There were animal feces. It was cluttered. There was food, garbage strewn about the residence, and was mentioned as well that the home was condemned by the Board of Health. That's why father moved. My brother mentioned that he moved to a new apartment. Well, the place where they were living was condemned, and so they had to move. And although the next residence was improved, there were also concerns about the condition of that home as well. And the conditions were observed by the social worker at the time. The court also considered other factors, including the father's failure to comply with certain action plan requirements, and most notably, as was mentioned, his failure to address the concerns about domestic violence through services, and also his failure to consistently visit with the child. There were 5 visits that were canceled due to his failure to confirm the visits. With regard to mother, the main concern about her was her continued relationship with father. But in April of 2023, she separated from him, returned home to Michigan to live with her mother, and has remained there since. And the court found, if you direct the court to findings 124, 126, and 127, the court found that since her return to Michigan, that she's been accessing and engaging in services there, and the department has been in regular contact with the Michigan Social Services who have been monitoring the placement. And in December of 2023, there was an ICPC approved for placement of the child, and he was, in fact, transitioned to mother after trial. Based upon all of this evidence, the court correctly determined that father was unfit to assume parental responsibility for the subject child. And we would ask this court to affirm the trial court's decision. Unless there are any questions, the department will rest on this brief. Thank you.
Ms. Aranis.
Good morning, members of the panel. May it please the court, my name is Tina Aronis for the child. DCF has thoroughly addressed many of the issues in this case. As you've heard, there's ample evidence to affirm the lower court's findings and conclusions of law that father is unfit by clear and convincing evidence, and that mother is currently fit to care for the child. My client requests that this honorable court affirm the decree issued by the lower court finding father unfit and granting mother custody. At the time of his removal, my client was 3 months old, and he had been exposed to marijuana use in the home by father, paternal grandfather, and father's sister. There were multiple incidents of domestic violence inflicted upon mother by father, by sister, by paternal grandparents, and there was domestic violence among family members between the paternal grandparents. He was also exposed to deplorable living conditions, and he was kidnapped from the arms of his mother. This is a case where father is dissatisfied with how the judge weighed the credibility of the testifying witnesses in the 20 exhibits admitted. Custody of 3 minors states that it's within a judge's discretion to evaluate credibility of witnesses and to make her findings accordingly. She was not obliged to believe the testimony of father or any other witnesses. Judge Tan issued 146 findings of fact and 33 conclusions of law, and father is only challenging 3 of those. He mistakenly treats this case as it's the custody case between the parents, but this is a protective case brought by the Commonwealth, and DCF oversaw the parents throughout the case, and there was also an ICPC conducted by the state of Michigan. And both the Commonwealth and Michigan found that mother had addressed the protective concerns and that she was able to care for her son. I would also like to discuss the ongoing domestic violence that occurred in the home. Father states that he was determined ineligible for the Intimate Partners Abuse Program, but he was only found ineligible because he denied the domestic violence in the home. To the contrary, mother, at the time of trial, was enrolled in a DV class and was set to start. The lower court did credit mother's accounts of controlling behavior and abuse by father and his family, and she did not credit father's allegations of domestic abuse by mother. Judge Tan appropriately weighed the evidence before her, and if there are no questions from the panel, I would rest on my brief.
Seeing none, thank you. Thank you all. We'll take it under advisement. Our next case is 24P34 Brian Sweet versus the Massachusetts Civil Service Commission.
in the conference suite, Your Honor.
Okay.
Good morning, Your Honors.
Mr. Collins, we're going to wait for we're missing one of the lawyers.
Okay.
Thank you. Mr. Collins.
Thank you. Good morning, Your Honors, and may it please the Court. My name is Ian Collins, and I'm representing the plaintiff, Brian Sweet. As the record shows, he was terminated in 2010 by the state police, and he appealed that termination to the Civil Service Commission and essentially won that proceeding. I say he won because the commission, having seen voluminous evidence and heard testimony, ordered the Department of State Police to reinstate him. And the only charge in which Sweet did not prevail entirely was this rather unusual notion that he must have known what caused a still unknown noise in the state police barracks in 2007, even though when asked months later he said he didn't know what it was. The problem, the overall problem, is that Sweet, despite his 2013 victory, has never been reinstated or made whole. And the real problem specifically in this case before you today is that the commission reopened and changed its 2013 decision in 2017 primarily because he lacked a license to carry. And the commission in doing so overstepped its authority in two main ways. First, to reopen the case in this scenario really flies in the face of what the case law has done to hem in an agency's discretion to reopen a closed adjudication.
Do you agree that there are instances where reopening closed matters is appropriate and warranted?
Yes, and I do, and I believe that the SJC has explained that quite well in a sexual offender case. And it is explained there that an agency would retain the authority to reopen a closed proceeding where it was demonstrated that the evidence relied on was in fact unreliable, inaccurate, fraudulent. There are cases, Aronson speaks to the appropriateness of reopening a case where fraud infected the evidence that was relied upon. And what I think is so easy to do is to simply read the lines in the cases that talk about that power to reopen and not read the remainder, which will then go on and say that finality is an important value in the system, that there are limits that have been delineated. And in this case...
Wouldn't it be in an interest to not have a miscarriage of justice, though? I mean, why wasn't it inaccurate that there wasn't a proper record of his long history for being untruthful?
I'll address the first part of the question as I understood it first. It certainly is legitimate to reopen a case to prevent a miscarriage of justice. But in this case, what has really happened in this case is not to identify a miscarriage of justice, but simply to apply fresh judgment to facts that were already known to the commission. You'll see in the record and in our briefs that the commission was aware of it, that Sweet did not have a license to carry when it issued that 2013 decision. It had been mentioned, number one, it was in the record. Number two, it had been brought up by the state police in their proposed findings. And this commission was aware of this, constructively or actually, when it issued that 2013 decision. What we really see...
At that time, was there reason to believe that he would never be issued a firearms license from the state police?
I would say that there was not reason, but I would also point out that that's actually not factual. He actually in 2020 did obtain a license to carry.
Yeah, but that was from the town of Andover, right?
That was from the town of Andover.
That doesn't permit him under the state police regulations to be a trooper, right?
The state police regulations speak to the
It has to be issued by the colonel.
The state police regulations speak to the colonel authorizing troopers
and two colonels denied him a license.
They did, but the thing is that even if it was in the regulations that a trooper needed a license to carry in that particular way, that does not mean that he could not have been reinstated. And I would point first to...
How is he going to be reinstated?
He would be reinstated, and the commission, if he's reinstated, the state police would have the ability to attempt to discipline him through the procedures that are required.
Yeah, but he doesn't have an LTC, and they're not bobbies. They have to have a license to carry a firearm. He cannot get one.
Nonetheless, it remains true that they would have to bring charges against him and prove, and he would actually have recourse to the commission to show whether they were always enforcing that rule in that way. The department's regulations do not require termination for a first offense. There could have been alternatives.
But he's been out for so long now that he would not only have to, putting the LTC aside, he'd have to go back to the police academy, right? He'd have to start from scratch.
The regulations of the state police require a police academy, but those regulations do not trump the second major, in addition to it being an abuse of discretion to reopen in this scenario, the second form of error that the commission has made is really going beyond the statute that instructs it what to do in these disciplinary reviews. Chapter 31, Section 43. The commission is simply required to order the reinstatement of a trooper or of any employee who's covered when it has determined that the discipline imposed was not supported by just cause.
But that's not what happened. There was just cause. What they altered was the penalty. They never said there wasn't just cause.
I respectfully would disagree with that characterization. I think that to properly read Chapter 31, Section 43, the important part is composed of two sentences. The first requires that if the commission has determined that there was not just cause for an action, it shall reverse that action. That
just begs the question. What the commission said in 2013 was there was just cause for the punishment. But because there was a single instance of being untruthful, he only should have a 60-day suspension. But it turns out there was way more than a single instance of being untruthful, correct?
I would disagree. I read the statute to be specific to the actual disciplinary action taken.
If the commission didn't think there was good cause, how could they even give him a 60-day suspension?
What I would say is that the
No,
commission...
please answer that one.
Yes. Could you restate the question just once?
If there was no finding of good cause, how could they even mete out a 60-day suspension?
The answer is that there was just cause for a particular action against him.
Discipline action.
Disciplinary. There was just cause for, as the commission determined, in its own words, an additional incremental measure of remedial discipline, and that was 60-day suspension. But the commission
So we agree there was just cause for discipline.
I agree that there was just cause for the discipline of a 60-day suspension, but I would strenuously point out that we really point out that the commission determined that there was not just cause for a termination, and that distinction is very important, because the statute will fall apart if the commission is always authorized to simply modify a penalty. The first sentence will have no real meaning in many cases. If it doesn't have the obligation to reverse a disciplinary action that exceeds what just cause exists for, then the statute really will fall apart. All of its parts will not have effect in some cases. And it simply flies in the face of what I think we all know the commission's charge is to do.
So the 60-day suspension was okay?
Yes. Yes, we don't agree that that was appropriate for the nature of the allegation that was found, but we didn't appeal that. I'll put it that way.
On page 16 of your brief, you suggest that Sweet could have been reinstated without an LTC because other members of the police were permitted to work without LTCs. Is there a prohibition that if you don't have a license, you cannot be a state police officer, or isn't there?
I will say that there is a rule and a regulation that they must have a license to carry. That is in there, but that does not mean that they cannot reinstate someone without one. And if they do so, they
So
can
does that
proceed.
mean the state police violate their own rules on occasion? Is that what you're suggesting?
Well, they must have, when you consider the Adams case, where they argued to the Civil Service Commission that a state trooper who was found to be worthy of some discipline, but lacked a license to carry, had to be reinstated. And the commission cited the very case that I cited in my brief, Town of Brookline v. Alston, to say that the statute is unequivocal. And if the commission did not find just cause to support the action taken, it must order reinstatement. And it said that that held in that case. So it must be possible. And much as in the Brookline v. Alston case, the SJC pointed out in that case, it's certainly not ideal to order the reinstatement of someone who's currently unfit for the work.
So what are they to do? Where here, they initially felt that reinstatement was the appropriate course, 60-day suspension with reinstatement, and then they learned that he doesn't have a firearm license to carry as issued by the state police, which makes him ineligible to be a state police officer. So how can you order reinstatement if he's ineligible to be a state police officer?
Well, the statute is clear that they have to order his reinstatement even if there's some infirmity that exists. And it would be for the state police to take action, I don't know, move for relief from judgment, or if they were so confident that his LTC status was just cause to terminate him, well, they could have brought that in the charges before the commission in 2013. They could have reinstated him and then tried to go through the disciplinary process. And our point is that it's just not appropriate to fully prejudge what would have happened if they had moved to discipline him for his license to carry status. I mean, we know now that in the Adams case, they were required to take someone back without the license to carry. We know that the first penalty recommended in their own regulations for lacking a license to carry is not termination. And there are, as the other cases in the state have shown, there are instances where law enforcement officers return to work and they don't have a firearm.
When they revoked his license, he didn't appeal that, did he?
When they initially revoked his license, correct, he did not appeal that in a timely fashion. And one point of law that I would like to point out in my time here, opposing counsel has remarked on the Perez case to state that the regulations of the Massachusetts State Police have all the force of a statute and are due all the deference due to a statute. And I do want to point out that case is distinguishable here and in a way inapposite, whereas the Civil Service Commission statute certainly applies. And the statute at issue in the Perez case is sort of optional and mandatory. It's what's referred to as the Perry law. A public employer may stop paying an employee who is accused of criminal conduct under this Perry law. Stop paying them while the disciplinary procedure is going out. And it has numerous other provisions about what happens if a state agency does that. But it's optional for the state employer to use that or not. And that's key to the Perez holding. The SJC said, you know, that the SJC is saying that the Department of State Police in that case could use the Perry law or it could not. And in that case, it didn't use the Perry law, it used its own procedures.
Before you run out of time, Mr. Collins, can you tell us why this isn't moot?
It's not moot because, for a number of reasons. From his termination to at least the date of the implementation of post, he had been terminated without just cause and was due reinstatement and back pay for that. And it's also not moot because it's simply not appropriate to prejudge what post would do with his certification from the date of its implementation forward.
Okay.
If there are no further questions, I thank the board for its attention.
Thank you.
And I'll rest on my brief.
Mr. Farrell.
Good morning, Your Honors. May it please the Court. Sean Farrell from the Department of State Police. In 2010, Trooper Sweet became ineligible to become a state trooper or to continue to be a state trooper. Regulations, rules and regulations 545 and regulation 10.1.3 establish a required, a job requirement for all state troopers, namely the ability to legally possess a license to carry a gun. Back in 2010, Colonel McGovern, then Colonel McGovern, issued a revocation of that license to Trooper Sweet.
Why wasn't the revocation then a ground for termination?
Well, it was, the termination coincided, Your Honor, with the trial board hearing. The trial board, the State Police Trial Board actually terminated Trooper Sweet in 2010 based upon an incident at the Medford Barracks. That was the case involving
But not having an LTC wasn't a ground, though, right? Both of you in the commission say that when we learned that he didn't have a license after the 2013 hearing, that this was new to us, if I understand correctly. But you all knew since 2010 that he didn't have an LTC.
Right, and he was not employed. He had actually been terminated by the trial board, Your Honor, so he was separated from employment from the state police. I
guess I'm going to do a follow-up to Justice Meade's question. At the time of the termination hearing in 2010, his license had already been revoked, correct?
No, his license was revoked after the finding of the trial board and after the termination by the colonel. The trial board recommends termination to the colonel. The colonel imposes termination under rules and regulations. And it was after that point, at that time, that the Colonel McGovern, had issued a revocation of his license. And that revocation, and I think the record is clear, was based upon Trooper Sweet's long history of misconduct, history of dishonesty, history of excessive force, that at that point, the public safety and the fact that he is a law enforcement officer.
So if they didn't know about the license being terminated, why was it a reopening of the hearing as opposed to a new hearing based on this new evidence? And is there a difference?
Well, there is a difference, Your Honor. The Civil Service Commission, he obviously appealed to the Civil Service Commission. Under 131, under Chapter 140 of the gun license law, the revocation is appealable to the district court. Those are separate, really separate concepts. In this particular case, after the revocation took place, issued by Colonel McGovern, there was a 90-day period to appeal that. Trooper Sweet did not appeal that finding. It was only at that point he appealed a second revocation or denial of a gun license that Colonel Albin had denied him in 2014.
It's treated in your briefs and by Judge Mulligan, him not having the license was a new discovery, and it's not. You all knew that he didn't have a license.
Well, he didn't have a license after the trial board, after the colonel had terminated him. He had not been returned to service.
And correct me if I have it wrong factually, but it was cited as a ground for reopening it. That the commission didn't know in 2013 that he didn't have a license.
Well, the commission in 2013, there was a revocation. I agree, Your Honor, but that revocation. The Civil Service Commission order came down in 2013. At that time, the commission indicates that it was unaware of that revocation. Whether that, if you look from 2013 to 2017.
I'm sorry to interrupt, but it's in the administrative record. The commission says they don't know, but it's in their record.
And my answer, Your Honor, is that that record had not been developed at that point. It was only after there was an appeal of that, and at that point in 2013, 2014, Trooper Sweet had appealed that revocation. And the Civil Service Commission waited until that whole record was developed.
But isn't the standard, at least it's the standard in many other situations, it's only new evidence if they could not have known. They either knew or should have known. In this case, you can't argue that they either didn't know or shouldn't have known because it happened.
Well, Your Honor, the fact is, at some point in 2017, Trooper Sweet had been adjudicated by the district court as unsuitable to carry a firearms. He had appealed that finding up through, went to the Superior Court on a certiorari issue. That issue, Your Honor.
The finding was there.
It was there.
He appealed the finding, but the finding was there. You weren't going to let him work as a trooper because he had an appeal. His license had been revoked.
It had been revoked, and at that point, it was never, he never obtained a license to carry. He never obtained that license. And in fact, the Superior Court case that he appealed to under a certiorari petition ultimately was dismissed. It was moot. Strike that. He was dismissed for lack of prosecution in the Superior Court. And it was at that point that the Civil Service Commission had the full record in front of it and took action in finding that because Trooper Sweet was ineligible to be a state trooper, its order of reinstatement or order of discipline could not stand any longer.
Before your time runs out, opposing counsel says that even though it's in the regulations, a person can still be employed as a state police officer without a license to carry. Is that accurate or not?
That is, in this particular case, he cites Adams. Adams is not this case.
Is that accurate or not?
Is that accurate or not? Can a revocation of a license? No. I would say you cannot be licensed. You cannot be a state trooper if you have a revocation of a license to carry. In this particular case, the history, Trooper Sweet's history.
Not in this particular case. Not why it was terminated. My question is, can you be employed as a state police officer if you do not have a license to carry?
I would say no, you cannot be. Under the regulations, that a requirement of being a state trooper is that you have a license to carry, issued by the colonel.
Okay, thank you.
And given my time, I would rest on my brief. Thank you.
Mr. Quinnen.
Good morning, Robert Quinnen for the Civil Service Commission. With the court's indulgence, I think I'll pick up where we just left off. And I do also want to reiterate that with a permanent revocation of a license to carry, it is not possible for anyone to serve as a state trooper under existing Massachusetts law. And that's primarily due to a statute that is cited in our brief and the regulation that my brother counsel has referred to.
Has his license been permanently revoked?
It has.
It has been permanently revoked?
By the colonel.
Or is the thinking that it was revoked and there's no chance, even if he reapplied, that someone would issue him one?
So back in 2013...
Can you bring the microphone closer to you?
Sure.
Foreclosed from reapplying.
He is not foreclosed from reapplying to the colonel. However, he has been denied twice for reasons that the district court has affirmed, and he has abandoned any appeal of those determinations. So for at least 10 years, he was ineligible to have a colonel-issued firearms license. There is nothing this court or any other court could do to reverse that because of his failure to properly appeal that.
So when Colonel Albin first denied it, he denied it because his license had not yet expired, correct? That he came in prematurely.
Well, that was Judge Singer in 2014 who did that. Well, and yes, I believe it was Colonel Albin initially, and then Judge Singer affirms that. And then when he reapplied in September of 2014, he was denied on the merits with a 10-page letter. And that is what resulted in 3 years later in the judicial decision of Judge Carroll in the Framingham District Court that then precipitated the commission to reopen its case.
And they denied him because he was going to be a risk to public safety?
That's right, because he had been adjudicated unsuitable to hold a firearms license. And we don't know why it is that the Andover police chief 3 years later decided to give him a local firearms license, but that really is irrelevant because without a colonel-issued license, he cannot serve as a trooper. And I think what I'd like to emphasize is that back in 2013, the commission assumed that his license had merely been suspended because that was the typical practice at the time.
That's where you're throwing me.
Yes.
Because it's not what they assume. It's only new evidence if they didn't know or should not have known.
Yes.
In this case, isn't it clear they should have known? If they had looked at the records, they would have seen that his license to carry had been revoked, period.
In 2010.
In 2010.
But there was no way to know in 2013 that his license effectively had been permanently revoked because the permanency of the revocation did not take effect until 2014. And it wasn't until 3 years had elapsed.
Can you explain that to me? What happened between 2013 and 2014 that made it permanent?
He took an appeal from the denial of his license, and it was affirmed by the district court that the revocation was in fact permanent for a period exceeding 3 years, which then meant that he could not be reinstated under separate regulations that would have required him to obtain a new license and start back at the academy, get an attestation of good moral character from the colonel. Those are all things that he could not have done.
So what was new was the permanency.
That's right.
Okay, I understand.
Yes. To address a few other points that my brother counsel has made, I would urge the court to recognize the reasonably broad discretion that an administrative agency has been traditionally afforded under our case law for reopening a case in the interest of justice. I think that does embrace a miscarriage of justice standard, as we have argued in our brief.
Is that a catch-all in addition to false and inaccurate?
Yes, I believe that it could be viewed that way. I don't think any appellate court has intended to say that only if the evidence is inaccurate or fraudulent. I mean, here, it is an issue of the unreliability of the information that the commission had.
Would you maintain that if the information was incomplete and that made it inaccurate?
If it is substantially incomplete, such that the decision should not stand in the interest of justice, then yes, and we do have that situation here.
Could the commission, instead of reopening the hearing, could there have just been a new hearing based on this evidence that there had been permanency to the license to carry being revoked?
In theory, that might have been possible, but in fact, in 2015, I asked the Superior Court to remand the case to enable the commission to do this, and that motion was denied. So it wasn't until the 2017 district court decision, with the knowledge of the Superior Court judges who were overseeing the case at that time, that the commission issued the order to show cause, and without it having been responded to directly, it took the action it did in amending its decision. And as the court previously has noted, the commission did not impose any new discipline. It simply rescinded the remedial relief because it deemed it impossible to give it effect. And the commission has a strong vested interest at all times in ensuring that its orders will be given effect. And where that is simply not possible, it had to take the action that it did in this case.
What do you say to Mr. Collins' argument that it's not moot? And put aside the post thing, because we're not a prognosticative court.
Right.
We're reactive.
I would say based on other facts, such as the permanent revocation of his firearm license. It has become moot.
He says, what about the time in between when it had not yet become permanent? If he were right on everything else, I mean.
I mean, had he appealed the denial of his license to carry in a timely fashion, but this is a different case. This here truly was impossible, as the Superior Court recognized. And for the reasons stated by the Superior Court, I would urge this court to affirm the judgment below. Thank you.
Thank you all. We'll take it under advisement. We're going to take a short break. Our next case is 23P 1369, Princiotto versus Davies. Mr. Gini.
Good morning, Your Honors. Kevin Gainey here on behalf of the appellants, Barbara Princiotta and Marianne Princiotta, as the trustee of the Buttermilk Bay Realty Trust. This case comes to you following the decision on a motion for summary judgment brought by the appellees concerning property.
Can you pull that mic up into you a little bit? 'Cause
I can bring it up as far as it goes, Your Honor. Sorry.
You're too tall. I'm sorry.
I apologize for my limitations. The case involves the rights that are associated with a particular parcel of real property within a subdivision along Buttermilk Bay. The subject property arises from a subdivision of 23.61 acres. The property came to a group of 5 developers in 1955. Shortly thereafter, they caused the subdivision plan to be created. And if, in reference, when you look back, page 188 in the appendix is what I call the snow plan. That's a plan that shows the property as it was prior to development. And you'll see there that there are a series of 2 circular ways that benefit the property and lead to a singular house on the property.
That's on Lot 5.
Lot 5, that's correct, Your Honor. And that's
The only lot that had a house at that time, right?
That's correct, Your Honor. And then after the subdivision in 1955, in 1956, these 5 developers deeded house lots to each of them. The subdivision was comprised of 10 numbered house lots, 3 larger lots that each were in excess of a few acres that could be developed later, 3 subdivision ways, Kerner Drive, Arlington Drive, and Gainsborough Drive, and then a tennis court and an area identified on the subdivision plan as beach area.
Ways hadn't been fully developed yet.
No, at that time in 1955, the ways hadn't been, and that's why, Your Honor, if you look at the first deed out regarding Lot 5, and that's at appendix page 308, there were rights that went along with that property. Initially, paragraph 1 in the Statement of Rights was all rights of way pertinent to the property.
And does Lot 5 retain those rights in perpetuity unless there's an exclusion?
No, Your Honor. Under the law, those rights attach to the property and don't go anywhere unless there's either a grant, an abandonment, prescription, or a deed, a grant.
Did any of that happen?
As to Gainsborough Drive and Arlington Drive, never, Your Honor. As to Kerner Drive, there is evidence that that happened, and I don't dispute that. To the extent that someone can extinguish an easement right to a way, as we've noted, there is a procedure to do that, and it did happen as to Kerner Drive, but not as to Gainsborough or to Arlington at no point, and there's no suggestion that there's an instrument that did that. So because those express rights were granted in that initial 1956 deed to Beatrice Goldberg regarding this property, those easement rights attach to the property and they stick. They don't go anywhere unless something has happened. And there's no evidence that any of that happened.
Those rights need to be referenced in future deeds?
No, Your Honor. Pursuant to Mass General Laws 183:15, once an easement or an appurtenance is stated within an instrument of conveyance, it stays with the property until one of these other instances that could cause that to be terminated.
Expressed easement?
This is an express easement, yes, Your Honor. It's stated within the deed. And in fact, there are 3 statements of rights with regard to the ways within that initial deed that stick with the property. The first is all appurtenances to ways. That's paragraph 1. Paragraph 3 says that you should be an express easement to use Gainsborough, Kerner, and Arlington. So that's paragraph 3. And then paragraph 6 was an additional right that was included in deeds for 3 separate parcels, 6, 7, and 5. And the reason for that, I think, is manifest by looking at that snow plan at Appendix 188. Initially, there were these 2 circular ways that serviced the property, initially only Lot 5, but that was going to be needed to access Lot 5 going forward after the subdivision of the property. So Lots 5, 6, and 7 needed an express right to use that existing way to access those lots for development or any other purposes. But Lot 6 said that when Arlington and Gainsborough Drive were completed and improved and passable, that those additional easement rights to cross over those subdivided lots 5, 6, and 7 would go away. So the problems that I've identified in my brief with regard to the decision of the trial court are legion, and they go to these fundamental basic underlying principles of real property that the trial court either didn't understand or misapplied or misunderstood. For instance, the first instance that you've brought up, Justice Desmond, that easement rights stay with the property. The justice didn't understand that, and I think that it goes to a misunderstanding of the term appurtenance. And this is fundamental in property law, but the justice clearly read an appurtenance to require that whatever benefit to the property existed directly abutted the property. Well, that's not the case. It's never been the case. An appurtenance can be miles away from a property, and as this court has found in the Donadio case, away, even half a mile away, is an appurtenance if it gives some benefit to the property. In this case, clearly, Gainsborough Drive and Arlington Drive are appurtenances to the property, not just because they're express easements within a deed, but they provide a benefit to that property. Because the trial court justice had that misunderstanding of these fundamental principles, it colored every other portion of the decision. So in finding...
Even as an abutter, wouldn't she have rights to the entire way of Gainsborough?
Yes, Your Honor. If you hold an express easement to a way, it is established in basic law that you have the right to use the entirety of that way for any purposes that are reasonable and within the scope of the use of a way. And the justice didn't understand that or misconstrued it. And then in reading paragraph 1 of the initial deed to Beatrice Goldberg, where it says that the property shall have all pertinences to ways, and then the justice read that as somehow limiting paragraph 3, where the property benefits from an express easement to all of the ways. So he said that because paragraph 1 applies to appurtenances, he misunderstood that an appurtenance meant abutting, so he said that she only had the right to use the portions of those ways that directly abutted her property, and that's simply not the law.
Let me ask you a couple of questions, just kind of from 30,000 feet.
Yes.
Before we kind of get down.
Yep.
So she buys the property in foreclosure in 2009, I think
Correct.
it is, right? And so from 2009 to 2018, and prior to buying the property in foreclosure, she walked the land, as I understand it, and she examined some deeds in the subdivision thing, right?
Yes.
And she enjoyed going down the road to the beach until 2018.
That's correct, Your Honor.
So first question is, when she did that, enjoyed for 9 years going down to the beach,
Yes.
were there other folks within the subdivision who were also using the beach?
It's my understanding that, yes, other people within the subdivision were using the beach as well.
And what changed in 2018? Some folks moved into one of the properties on the southerly portion of Gainsborough, right?
No, Your Honor. My understanding, and what's in the affidavit of Ms. Princiotta, that's part of the summary judgment record, is that the parcel directly abutting Ms. Princiotta to the west, which is parcel 6, which is owned by Jacobs, they moved to the property full-time, year-round. Prior to that, it's my understanding, it had been used seasonally by their family, and their family had owned it for years prior to that. But they'd use it seasonally. They moved in there year-round, and apparently at that point in time, for reasons that I don't know, they're not in the record, there was some change, and the Jacobses at that point in time began asserting that Ms. Princiotta didn't have the right to use the beach area. So there are 3 issues really that I address in the brief, and I really think that they're the most important ones. So first is the issue regarding express easements that we've already addressed. The second is the application of the derelict fee statute to this property. just as I'm sure aware, the derelict fee statute provides that to the extent that a parcel of real property abuts a private way, unless there is an express reservation of the fee to the way within the chain of title from generally the original developers, the derelict fee statute applies even retroactively, and the owner of that lot owns to the center line of that private way, and again, similar to an easement, enjoys the right to use the entirety of the way for all purposes. So I think it's clear that the documents in this case establish that Lot 5 benefits from an absolute right to use Gainsborough Drive and Arlington Drive through express easement, and then the derelict fee statute, which is applicable, applies in this case. It gives Ms. Princiotta and Lot 5 the same rights. I note that the only case that I found in the defendant's brief that suggests that because a property abuts a private way, it doesn't necessarily get these rights is the Higney versus Pathways case from 2015. But I need to note that that case involved registered land, and in two portions in that case, the court specifically said that the property had been subdivided in 1935. So the court specifically held that because the property was subdivided in 1935 and because it's registered land, the derelict fee statute can apply. And that's true because it's a specific and distinct carve-out that applies only to registered land. This land is not registered, it's recorded land, so the derelict fee statute must apply. So
Did Judge Perino even reach the derelict?
he chose not to address it, Your Honor. It's not clear why. There's a footnote of a brief exchange that occurred during the summary judgment hearing where I suggested that the derelict fee statute applied, and the justice made a comment that some things don't get over the bridge. But it's not clear why he chose not to apply the derelict fee statute because clearly it's applicable in this case. This is registered land, property abutting a private way, even though the property was subdivided in 1955, which is prior to the 1971 enactment of the derelict fee statute, it expressly retroactively applies to all properties that are not registered. So once we find that Lot 5 benefits from these rights of access over the entirety of Gainsborough and the entirety of Arlington, then I think we need to get to the third issue, which is the right to use the beach area. I'd note that to the extent, if my clients were tennis players, we'd be having the same argument regarding the tennis court that's shown on the subdivision plan, but she's not, so we're dealing with the beach. We've identified three separate instances where the courts have found that if any one of these items is present within the chain of title or viewing the development as a whole, that an area identified as a beach area or park will be viewed as a common amenity that was intended to be used as a common amenity for all the lots. And I point out again.
Let me ask you one other question.
Yes, please.
For a second. So when she uses the beach, does she drive down Gainsborough Street or does she walk down Gainsborough?
If you look at the subdivision plan, she would walk. Her house, Gainsborough is not particularly long. It's only a few hundred feet long. And her house is bounded to the east by Gainsborough. So it was a very short walk for her to the beach.
And when she gets down there, does she enjoy the beach at the bottom of the road, or does she actually go around to the area behind her that abuts the water on her lot?
Both, Your Honor. But it's important to note that the area that abuts her lot directly, that's an intertidal zone that is fully submerged at most of the tide schedule. There's a short period where some limited portion of it is exposed. And I'd state that that's in her affidavit, but as somebody who's been there myself several times, it's not a usable beach.
Is there anything in the mortgage on page 334 and 335 of the appendix that sort of creates a belief that the beach area wasn't included?
So, no, Your Honor. So what happened was title to the beach area and then title to the lots, and then this remaining area was severed all the way back in 1956 and held separately by the developers and then separately by the people going forward. So the mortgage was granted only as to Lot 5. But that doesn't mean that all these other attendant rights don't attach and Lot 5 doesn't benefit from those rights, because it does. So because Ms. Princiotta has the absolute right to use the entirety of Gainsborough, which has over 26 feet of frontage on the beach area, she has the right to access the beach area. So she satisfies that requirement. Because the only usable beach area in the entire subdivision is the area identified as beach area. And the developers identified it as beach area. They didn't identify it as a lot number.
We're going to have to leave it there. Thank you. Your time is up.
Thank you, Your Honors.
Mr. Johnson.
Good morning, Your Honors. Attorney Jeffrey Johnson, on behalf of the appellees, along with me is Danielle Andrews Long, who assisted in the brief but isn't going to argue this morning. I guess I would start off my argument by suggesting that my brother's oral argument seems to have abandoned his claim to an ownership in the beach, which is refreshing. I don't think that there's any interpretation of any of the deeds in these chains of titles. It would suggest that his clients have any interest in the beach area.
You think they have a right to use the entire way?
I don't interpret it that way, Your Honor, because it has to be appurtenant. And if she has no right...
What about as an abutter?
What's that?
What about as an abutter?
As an abutter to the way, she can use that portion of the way to get to and from her house to the public way. But if there's no other appurtenant right that she has...
Hold there. But doesn't the case law tell us that as an abutter, she has the right to use the entire length of the way?
If there's an appurtenant object, that's my interpretation. I would concede...
Wait, I'm confused. So does that mean she can go to her driveway to get in and out, but she can't go further down the way?
She could go to the end of her property is my interpretation of the case law, but I don't think that it's worth fighting over in this case whether she can use Gainsborough to its terminus. The real argument is, for what purpose can she use it? If she has no easement right in the beach, which we say she does not, all she can do is go to the end and turn around. If you look at the subdivision plan, you'll notice that Gainsborough does not go all the way to the ocean.
What page in the record?
This is 192, Appendix 192. If you look at that plan, you'll see that Gainsborough, although it abuts her Lot 5, and it abuts the Davies property, only goes down and stops at the beach. It doesn't go beside the beach, it just goes to the beach. And if she has no reason or any easement rights in the beach area, then she has no, that's not appurtenant. But what's important in this case is that through two different petitions to partition, the beach area was conveyed first to 6 people and then to 3 people, or three families. And the Gettys took title to their interest in the beach area and the fees and the ways. By the way, those petitions conveyed the fees and the way. All right, specifically the first petition, in the cross deeds, the fees and the way went out. Right, so the derelict fee statute becomes inoperative because it's clear in the conveyances who owns the fee in the way. Princiotta still has a right to go through those streets. And you can't interpret the 1955 deeds without looking at the Snow plan. You have to look at the two plans, because the plan of the subdivision.
The lower court didn't address the derelict fee argument. Is that a problem?
I'm sorry, Your Honor?
So the trial court didn't address the derelict fee argument that was raised?
Well, it actually did, in my opinion. It said that it wasn't operative, and I interpret it to mean that because of the conveyances of the fee out, didn't have to look at it. If you look at the derelict fee statute, it specifically says unless otherwise, right? Unless otherwise. And in this instance, we have 6 people who exchanged the fees in these ways. Now, they didn't get rid of the easement rights, whatever they might be, and you can only interpret the easement rights in relation to what's on the ground, because...
On what page of Judge Perino's decision will I find the discussion on derelict fee?
Well, it's in his footnote.
In the footnote.
It's in his footnote. But again, since this is a review of a summary judgment, my understanding is you're deciding this de novo, and I'm asking you, look at these deeds. Okay. Look at the words in these deeds, in these conveyances, and I think you have to conclude that she doesn't own to the midpoint of Gainsborough. She doesn't own to the midpoint of Arlington. She has the right to use them, and I'll leave it up to your discretion as to what length and what extent, and maybe the judge was wrong about whether she could go to the end of Gainsborough and turn around, but she has no easement rights in the beach. It's clear. The beach was conveyed away. The deeds are unequivocal. When the Gettys lost Lot 5 to foreclosure, and the mortgage description didn't include any other rights to the beach or anything else, any other property.
Did it have to?
As to ownership, it certainly did.
As to ownership.
As to ownership. As to easement rights, no. But they never got an easement over the beach by implication or otherwise. Never. No document says that anybody has a right to an easement to the beach. And as to rights by implication, common scheme, it's his burden to show that under the facts as attendant to these conveyances that it was intended. And I would suggest to Your Honor, I've been practicing law in Cape Cod for a long time, maybe too long, some would say, and I've seen a lot of beach subdivisions. And the owners who own on the water, whether it be a lake or the ocean, they've already gotten their benefit. They have their view. They have their access to the water.
Where in the original conveyances or the chain is Lot 5 carved out from the beach area?
In the original deeds by the developers, there were deeds to the individual lots, and in the first deed out to Mrs. Goldberg, Lot 5 gets conveyed out. I'm not sure what item in the appendix it is, but Attorney Joel Stein very eloquently discusses this chain of title. Mrs. Goldberg gets Lot 5, not with her husband. The other families were husband and wife as to the individual house lots, and the husbands, and then later, 3 years later, a 6th player came in to play, get title to all the other acreage, other than the 6 house lots.
Isn't it the, as opposing counsel said, isn't it the original conveyance that controls from that point on?
Unless they convey it back out.
Okay.
So we have Mrs. Goldberg only gets Lot 5. It does not speak to an easement of any sort over the beach area. Okay, it speaks to easement areas over the roads and over the traveled ways. And it also discusses, if you really read it, where the traveled way is over lots 5, 6, and 7 only gets extinguished when Arlington Drive and Gainsborough are fully developed, and they never have been.
Was the
So that's
beach area-
as to the easement areas, but as to the beach, it's silent. And then the men, to be sexist in the late 50s, get title to the rest of the subdivision, which includes the beach.
Was the beach area identified as the beach area at that time, in 1955?
It was labeled beach.
It was labeled the
It was
beach.
labeled beach, right? If you look at the snow plan, it doesn't show it as a beach area, and if you look at the next plan, the petitioner's plan on the land court, it's not shown as a beach. But in the subdivision plan from 1955, it says beach area. It doesn't say common beach area. It says beach area. And there's a specific deed out to the families of the extra acres, excluding these house lots, and the beach area. And the beach area is owned by 6 people. Then there's the Chickenelli partition, narrows that down, and then the Getty petition to partition narrows that again down. And you have to look at those deeds coming out of those petitions to partition, one of which had an agreement for judgment, and made it very clear who owned what they were conveying. The beach area went out. Ultimately, the beach area went out to 3 families, okay? And the Getty, who survived as an owner of the beach area, his family having lost the house, he conveys specifically and unequivocally his 1/3 interest in the beach area and the extra land.
This is a crazy question, but I'm going to ask it anyhow. So just try to work with me for a second here. Let's assume for the sake of discussion that lots 1 and 2 have rights to the beach area.
So lots 1 and 2,
Let's just
In fact,
hypothetical.
do.
Hypothetical.
no, they in fact do.
But let's assume that they do. And lot 2 conveys their beach rights when they sell. Does that affect lot 1's rights?
No. No, whatever, if a family owns 2 lots, which in this case, that actually happened, and as part of the Chickenelli petition to partition, the Chickenellis gave up their rights to the beach area except for a walking access easement over the beach to get to their dock on their land. They specifically retained an easement, but they gave up their fee in the beach area. And that's a matter of public record. So that easement still exists. I understand they don't use it, but that's not in the record and not before you. But what we have here throughout this appendix are very clear documents written at a time before the derelict fee statute, but very clearly say what the rights are as to easements over the streets, if that's what we're arguing about today.
I'd like to, again, I thought I knew the record pretty clear. I need you to tell me where Lot 5 is excluded from use of the beach area. Because that seems to me, again, the road, I've heard both sides' arguments. The beach area to me is what controls this. So where is it that it's excluded?
All right, so Mrs. Goldberg gets a deed for Lot 5. She does not get an easement over the beach area in that deed.
Can you point to someplace in the record where it's excluded from lot 5?
It doesn't need an exclusion. Lot 5 needs a grant. If you're given a lot number 5, and as part of that deed, you don't get an easement over the beach area, you don't get an easement over the beach area unless you can prove otherwise, common scheme and that sort of an argument. But he falls flat on it.
He makes that argument though, right?
He made that argument, but it falls flat. If you look at the case law, it says the attendant circumstances.
Okay.
So again, husband and wives get all the deeds to the individual lots, Mrs. Goldberg being the only exception without her husband. But then the husbands alone get a deed to the beach, and the extra acreage that is yet to be developed. And I would suggest to you, as I started to say, being a conveyancer on Cape Cod, it's those lots, in order to sell them, typically one would promote an easement area, an easement benefit over the beach. And who would be the people to give that easement? The husbands in 1955, and later the successors in title to the beach area. The Jacobs and the Davies, who own the beach area now, when they develop the other acreage, they may in fact offer easement access over their beach area. Ms. Princiotta has no easement. She has no fee interest. The beach area is not hers to enjoy in any fashion. And to suggest the fact that it must be implied because of the high water mark or whatever, people buy oceanfront property for the view, for the enjoyment.
We're going to have to leave it there.
Thank you.
Thank you. Thank you both. We'll take it under advisement.
Thank you.
The next case is 24P 435, Shandra versus Caprio. Mr. Morgan.
May it please the Court, my name is Jason Morgan. I represent the appellants Peter DeCaprio, Timothy O'Brien, and Crow Point Partners. Before you are an appeal and a cross appeal, our appeal really focuses on very discrete and defined legal issues. We've identified four, two of which are really inextricably intertwined. And the cross appeal really addresses, for the most part, questions of fact, which I would suggest don't satisfy the clearly erroneous standard. Our legal issues obviously are reviewed de novo. Those issues being the first two that are connected are, did the trial court err in finding that a reduction in pay, a reduction in compensation is a violation, especially where the factual findings were that the plaintiff, Mr. Shandra, failed to generate any meaningful revenue and failed to satisfactorily perform, which again would be subject to a clearly erroneous factual finding because the court did find that he failed to perform. And the court also found that Crow Point was justified in terminating Mr. Shandra later in 2016. So the suggestion that they wouldn't be justified in simply reducing his pay ahead of time before terminating him, that would be a violation of the Wage Act. The corollary legal issue to that is, and where the case law is very clear, is that where it's a prospective reduction, meaning I've told you I'm reducing your pay, and going forward, I'm going to pay you 100% of that reduced compensation, that a prospective reduction is not a violation of the Wage Act. It may constitute a breach of contract, but it doesn't, under the case law, constitute a violation of the Wage Act. The third legal issue has to do with basically the interpretation of the compensation that Mr. Shandra received under the side letter agreement. And we put forth the case law that basically says a couple of things that are really important. Where compensation is undefined or contingent or discretionary to the company, it doesn't constitute wages. If it doesn't meet the common indicia of pay, meaning that it has an established salary or an established pay rate that is paid on a set time frame, then it doesn't qualify as wages under the Act.
What was the time frame for his payment?
I'm sorry?
What was the time frame?
There was no time frame in the side letter that indicated when he would be paid. In fact, the determination was, and the side agreement is quite clear, that the compensation wasn't established. There was no time frame for payment. There was no amount for payment. All that was required is that he received what are called guaranteed payments that would be equal to Mr. DiCaprio and Mr. O'Brien.
But I mean, factually, what intervals did those occur?
They weren't consistent. At some point, they eventually got onto a more consistent time frame. But when the side letter was signed, for the first year after the side letter was signed, there was no set determination of pay. It was paid in chunks here and there.
Payments at some point?
At some point down the road, but not in the first year of the side letter, and not subject to the side letter, were there monthly payments in the beginning. So you had an entire year or more where there was no set schedule. They were paid in chunks, in terms of like he needed X amount of money, they paid him X amount of money, and they would pay him based on what they were getting at the time. But in the beginning, there was no set schedule in terms of the periods of pay, not weekly, biweekly, monthly, anything like that. Eventually, down the road, they ended up paying him consistent with how they were paying themselves, which was on a more consistent basis. But again, it was up to their discretion, which is part of what puts it outside of the wage, because they could determine when to pay him, and that was always the case. And they only paid him when they paid themselves.
Wasn't there one point where they paid him less than the partners, the other partners?
That's the subject of the claim. Right, so in March of 2016, you now had, based on the court's finding, you had over 2 years of non-performance by Mr. Shandra. At that point, they could have terminated him, and that's what the court said they were justified in doing several months later. But what they did as an interim step, they said, we're going to reduce your salary, one, because you're not performing, and two, because you've already been paid $150,000 more than we have, that we're going to reduce your salary prospectively, and I think that's the important thing. They didn't get to March 2016 and say, we're not paying you for the work you did up to date. He was paid 100% for the work up to date. What they said is, going forward, your pay is going to be less, and going forward, they paid him 100% of that lesser pay.
Who drafted the side letter?
I'm sorry?
Who drafted the side letter? The second side letter, who drafted it?
I mean, it was negotiated between Mr. Chandra's counsel.
Drafted it.
I don't know. It was negotiated between Mr. Chandra counsel and counsel for Paul Izzo was Mr. Chandra's counsel. He drafted it in conjunction with counsel who happened to have been, I think at the time, the brother of one of the principals, Peter DECAPRIO. So you had counsel for both sides that were drafting it and going back and forth. So I wouldn't say there was one drafter. I would say it was a negotiated agreement amongst two sophisticated parties, both represented by counsel.
And the $150,000 was called a loan in that letter by both sophisticated parties.
The loan was requested by Mr. Chandra and agreed to by the company.
Referred to as a loan. It seems as though that somebody's distancing themselves from the $150,000 as a loan.
The loan itself, really, by law, is not a loan because it was never intended to be repaid, and it never was repaid. It never had an interest rate tied to it. It never had.
Call it a loan.
Why they classified it as a loan in the agreement is not within my knowledge, other than that's how they wanted to characterize it, because they wanted the ability to not have it look like compensation at the beginning. Even though Mr. Chandra testified he never intended to repay it, and he never did repay it, and the fact that he never repaid it makes it compensation.
Why did they want it to not look like compensation?
Mr. Chandra requested that. He wanted the ability to call it a loan so that when he received it in 2014, he could say it's not taxable to me in this year. But when he...
So if that's true, and Mr. DECAPRIO went along with that, right? It seems like that he doesn't have clean hands.
They agreed that they would classify it as a loan in 2014.
Circumvent taxes.
Well, I'm not suggesting to call it a loan was illegal in the beginning, but when he didn't repay it, it automatically became compensation. And so when he then confirms, because he never did repay it, and the case law that we provided you is that when you look back at when this loan qualifies as income and no longer a loan, you go back to the date that the monies were issued. So if he had repaid it, and it's possible that he could have, or if profits had come in which would have allowed him to offset the amount of the loan, which was possible, but that never happened. And in the cases say, once it never happens, then you have to go back in time to when the money was issued to determine what you qualified as at that time. So basically, you could call it a loan legitimately up front, but once it's no longer payable and no longer paid, you have to go back in time to say, okay, it was compensation at that point. It was no longer a loan. And that's sort of the fourth legal issue that we identified was
I have a question.
the classification of that. Yes.
In the portion of your argument that Mr. Shandra didn't earn the wages.
Yes.
Are you relying on trial testimony from the breach trial before the judge as opposed to the summary judgment record?
Relying on...
That he underperformed?
Well, both, because we had factual findings. I mean, the court never addressed the issue at summary judgment in terms of the earn part, if you will. It simply said because you didn't pay.
Summary judgment was decided before the trial.
Yes, correct.
So how can we use trial testimony? It wasn't before the judge on summary judgment.
Well, it was before the judge on summary judgment.
Eventually. But
no, it wasn't. We submitted summary judgment papers as well as a motion for reconsideration and identified all of these issues in those papers. It came up in trial because the judge hadn't made factual determinations in terms of thinking that part of it was relevant to the wage determination. And that's why we think it was error to not do that. It was legal error to make a determination on the Wage Act violation without considering the fact that he hadn't, quote unquote, earned the monies.
Was the motion to reconsider post-trial?
No, it was right after the summary judgment order issued, so it was pre-trial. And we claim error. We identify that as one of the errors in not allowing the motion for reconsideration as part of the record. The motion for reconsideration is part of the record. And so that particular argument, though, does line up with what the judge should have done at summary judgment, was to hear the evidence on earned, because at trial, the judge actually found that every factual finding was that he didn't earn the money, that for over 2 years, up to the point where they reduced his salary, the judge found he did not perform, produced no revenue, and he found that a few months later, they were actually justified in terminating him because of that.
Sorry.
Yes.
He says that he wasn't required to generate revenue.
He says that, the judge says no. And the judge says that the agreement was, and the case law, and the judge relied on two things, the factual and legal. The judge found cases that we've cited as well that say in an employment situation, you can't just sit back and do nothing and expect to be paid forever. That you have to do what's reasonably required of you to perform to earn the wages, particularly in a wage case where you're earning wages. If you don't earn the wages, you don't have a Wage Act violation.
To reduce it, did there have to be a reduction in the legacy revenue? And please explain to me the difference between non-legacy and legacy revenue.
Yeah, it's a nonsensical argument in my opinion, because there is a condition, and that's part of what makes this discretionary and not fall within the Wage Act. One of the things that makes it discretionary and contingent is if the legacy revenue had dropped to a particular point, he would have not been able to be paid what he's claiming he should be paid.
We start with the distinction between the legacy and the non-legacy payment. What's the difference between those two things?
Well, the distinction is that, and it's an important distinction from my point, because there was only one source of legacy revenue, and it came from Timothy O'Brien, who's in the courtroom today. And the judge found that that was the only...
What is legacy?
It's basically Wells Fargo revenue that Mr. O'Brien had brought in and was an existing client base. The non-legacy revenue would be new revenue that someone like Mr. Shandra was supposed to bring in. And the court found that he didn't. And the work that he did on the legacy revenue and other revenue that was in the company, he actually lost money on. And so you have these factual determinations. When we go back to the earned component, the court found essentially they were justified to terminate him because he was doing nothing. In fact, he was a cost center and not an income center. And the court said...
Does the revenue stream have anything at all to do with the side letter?
It does, because the side letter is if I... The side letter talks about they agree to employ you in a principal capacity, which suggests an owner capacity, at least as equal to O'Brien and DECAPRIO, the other two principals, each year as compensation for your services, which compensation shall be paid as guaranteed payments, which are profit distributions. The services part is what I think factually, not legally, the judge said legally, you can't just have an employment agreement that lasts forever where you sit back and do nothing.
The side letter doesn't mention anything about revenues.
No, but it mentions services, and what the judge found is that services include generation of revenue.
So the side letter seems to me to implicate that they could lower their own salaries, and that would automatically lower Chandra's salary.
Correct.
But as you pointed out earlier, they could have fired him, but they didn't. So since they didn't, that letter controls.
Yes, and the point of the letter is that you get compensation for services. That's the quote from the letter. The judge found that he wasn't performing the services that he agreed to perform, that all the principals agreed to perform.
So again, pursuant to that letter, when that happens,
Yes.
they could lower their own salary and his. At one point, they didn't do that. They lowered his, but not theirs.
Yes,
So
and-
that's a violation of the letter.
And so I would argue that it's a possible violation of the letter, but it is squarely outside of the Wage Act. And that's what the cases say. The Calixto case, the Condes case, which Justice Desmond was on, all say that you don't get to pursue a Wage Act violation for what you claim is a breach of contract. It has to fall under the Wage Act. And so that's what we're saying. It's quite possible that he could say, you breached the side letter by not paying me. But because they did it inconsistent with the Wage Act and reducing it prospectively and paying him 100% of the reduced salary, that's not a violation of the Wage Act. You can have one, but not the other. And so that's what the cases, the Calixto case, the Mass State Police case say, and basically the case from Condes that Justice Desmond was on says it is not a Wage Act violation to reduce an employee's salary by, in that case, a furlough, by anything. It could be a breach of contract, but it says squarely, just because you have a breach of contract doesn't mean you have a Wage Act violation. That's what this SJC and the appeals court has said already.
But the furlough case really dealt with whether or not he actually earned the monies.
Threshold issue, correct. You have several layers. I see my time is run, but you have several layers to get to a Wage Act violation. It has to qualify as wages, you have to earn the wages, and then it has to be something other than a prospective elimination or non-payment. So you have these different layers. We win if any of those are not true. I think all three of those are true. And so that's sort of the steps that you have to go down to do that.
Okay, thank you. Mr. Nesgos.
Good afternoon, Your Honors. Nick Nesgos on behalf of AMITABH Chandra. I will start with the Wage Act violation and ask the justices to affirm that decision and then turn to the contract claim. With respect to the side letter at issue, as has been mentioned, it conditioned Dr. Chandra's pay. It required that he be paid equally to Mr. O'Brien and Mr. DECAPRIO. As of 2016, these payments were being made through a wage service. Bi-weekly, he was receiving the pay. And during that was the case throughout 2016. There is nothing in there is nothing that takes this reduction in pay outside of the Wage Act.
Why isn't it a breach of contract solely?
It is both a breach of contract and a Wage Act violation. So the prospective pay cases upon which my brother relies, Calixto and Mass State Police, deal with prospective future compensation that a plaintiff claims he would have been entitled but for the breach of contract. So in the Calixto case, there's a Warren violation. The plaintiffs in the class claimed that they were entitled to 60 days additional notice before they were terminated. And what they sought was the pay they would have received during those 60 days. In the Mass State Police case, it's what the plaintiff claimed was an improper furlough. So again, they were seeking prospectively pay that they claimed they would have earned had they been allowed the opportunity.
Chandra's pay is still contingent on what O'Brien and DECAPRIO are paid.
It's contingent in that sense, but in that broad sense, Your Honor, all pay is contingent, right? So pay is contingent about your pay can be adjusted from time to time. The people who work at my law firm, their pay may go up, it may go down. But we have the obligation.
My pay isn't based on how much Justice Desmond makes. It's not contingent on that.
But nothing in the Wage Act says that conditioning pay on the amounts that others make. In other words, you can agree you're going to be paid $100,000.
No, it's not fixed if it's contingent on a variable.
It's fixed at the same rate of pay that the two other individuals make. So if everyone's agreeing to get paid $300,000, that's what they get paid. That's how it's fixed. And here what happened was, during the time period at issue, they simply docked his pay. There's no evidence, by the way, in the record that they communicated to him that going forward you will receive only X amount.
Well,
He
actually made more money than O'Brien. And
Excuse me?
He made more money than O'Brien.
He did not make more money than O'Brien.
When you include the 150.
Sure, and as the judge correctly ruled, the $150,000, if you read the side letter, expressly says that in addition to the obligations to pay X amount of salary, he shall be given a loan. The loan is to be repaid based upon distributions.
But it was never repaid.
It was never repaid.
He testified that he had no intention of repaying it. There was no interest set on it, and therefore it becomes income.
No, that's not. No, you're right.
He did, and he also said he did it to avoid paying taxes on it.
The testimony about that's not what the court found. But the issue here is that it's very clear in the side letter. It says that it conditions the repayment of the loan based upon there being distributions paid to Dr. Chandra. So there were two conditions. One is there had to be non-legacy revenue in excess of $1.5 million. And two, there had to be distributions to him from which he could pay the loan. Neither of those events occurred. And as a consequence, he had no obligation, and nor did he intend to repay that principal because he had no obligation to do so. That's what the loan says, and that's what the side letter says, and that's what the court so found. So the types of discretionary and contingent, the cases in which the courts say these payments are not wages, deal with categories of pay totally unlike the compensation paid to Chandra here. So they talk about discretionary bonuses. They talk about sick pay. They talk about components of profit that are paid. Nothing like, none of the cases that are cited by my brother have anything to do with the kind of compensation arrangement which is made here. And the side letter says that the payments made to him shall be compensation for his services. So it's clearly within the Wage Act. With respect to the contract claim, the court erred in ruling that the defendants were entitled to terminate Dr. Chandra based upon a failure to generate non-legacy revenue. The side letter differentiates between legacy revenue, meaning those revenues generated under the Wells Fargo funds that Mr. O'Brien was running prior to the time Dr. Chandra got there, and non-legacy revenues, that is revenues generated from other sources other than those three funds. And there is no requirement in the side letter that Dr. Chandra generate any non-legacy revenues. Dr. Chandra is what we call a quant. He's a quantitative methods analyst. He developed intellectual property that the company could use to develop a different kind of investment program. He wasn't given sales targets. He wasn't, in the side letter or otherwise, told he had to generate a certain amount of
Wasn't
income.
the understanding, whether it was puffing or not, that he was going to bring in all this revenue from Merrill Lynch, which never happened?
So the testimony on that from Mr. O'Brien is that the time the July 2014 side letter was executed, the due diligence requirements for the Merrill Lynch business had not been met, and that Mr. O'Brien was dubious at best about the ability of Dr. Chandra ever to bring such business in. And that understanding is imputed to the company. So there was no promise incorporated in the side letter or any promise upon which the defendants relied in entering into the side letter. And in fact, at summary judgment, the court dismissed the fraudulent inducement claim because the defendants were unable to muster any evidence that they relied on any specific representations made by Dr. Chandra in entering into the side letter.
So was there any way for Chandra to be fired?
Yes, and so the side letter sets up a set of protections for Dr. Chandra, and what it says is that he is to be employed as a principal continuing so long as he was a member of the company. The remedy for the company, to the extent they wanted to rid themselves of Dr. Chandra, was to eliminate him as a member. And in fact, they thought they could do that, and they threatened to do that. If you look at the January 2017 letter that Mr. DECAPRIO sent to Dr. Chandra, that's at Record Appendix 2 at page 246, you can see he threatens to remove him as a member, to remove him from the partnership, he says. So that's the remedy they have, and that's the way the side letter is constructed. You want to remove him, you have to remove him as a member. They could amend the operating agreement, and that would require 3 of the 4 board members, 71% of the membership interest, to do that. That's the protection that Dr. Chandra got for himself when he entered into the side letter agreement. So if one looks at the side letter, there is no person looking at that, Dr. Chandra, or any reasonable person looking at that would assume that he had some obligation to generate non-legacy revenue in order to continue his employment. There's no reference, as I meant, to non-legacy, to him generating non-legacy revenue.
What's his purpose? When you bring someone into an investment firm and they have no obligation to generate revenue for the firm, what's he doing there?
He brought his intellectual property.
Did that pan out into profit?
No, we're not challenging the court's finding that there was not a lot of non-legacy revenue generated. But the structure of this agreement says that he gets paid nonetheless. The structure of this agreement.
Why would they agree to that?
Because they were desperate to get his intellectual property and to get his quantitative methods into the company.
You wrote in your brief that he brought in over $35 million in assets from 2 funds, but did the judge make a finding of fact to that effect?
The judge, I think, said didn't write either way with respect to that. But it's not just, he brought that money in.
I think the judge said his performance was abysmal.
He didn't say that. He said it did not generate revenues. And I mean, Dr. Chandra testified there was a time frame for that to happen. But the point I wanted to make to the court is that the way the side letter is structured, it says that in the event that the revenues or profits generated from all sources of revenue, legacy and non-legacy combined, create a situation where the company doesn't have sufficient funds to pay Dr. Chandra to meet its obligations. In that event, it says, Mr. O'Brien and Mr. DECAPRIO have to contribute capital to the company to allow those payments to be made. That's completely at odds with the notion that he had an obligation to generate non-legacy revenue in order to remain employed. It's completely at odds with it. Further, it says in the side letter and in the side letter, it says that to the extent that non-legacy revenues never reached the 1.5 million cumulative level, he's relieved of his obligation to pay back the $150,000 loan. In other words, the failure to generate non-legacy revenue relieves him of obligations. It doesn't create an opportunity for the company to terminate him. That's the way the side letter was written to protect Dr. Chandra.
So first of all, abysmal's in the record. And secondly, you say that they were desperate to bring him on. Who was desperate to bring him on? I thought that Mr. O'Brien was reluctant to bring him in from the get-go.
Mr. DECAPRIO wanted him in, and they wanted his intellectual property. They entered into 2 separate operating agreements. But the point here, Your Honor, is the circumstances under which he was brought in and the inducements really not at issue. He came in. He entered into a side letter.
No, that's important, though, isn't it? Because he came in with the understanding that he's going to be bringing in this Merrill Lynch. These guys will move heaven and earth for him, I think was somewhere in the record. Right?
And that's what the court dismissed at summary judgment. The fraudulent inducement claim was dismissed at summary judgment. The notion that they entered into this agreement on the basis of those representations has been dismissed. So what we have is a contract which has certain protections.
So if they didn't bring him in for that, what did they bring him in for? This is what you're going to tell me about the quant?
Yeah, he was a quant, and he brought intellectual property. It's part of the operating agreement that he promised to bring in, and he did bring in intellectual property to the company. And that was valuable. And at the time, I think they thought that they were essentially fundamental managers, and they thought they wanted to have a quantitative base as well. And that was what they wanted to do. And the fourth director, Phil Lucier, with whom Dr. Chandra worked, also wanted to continue to develop that business. And so that's what they tried to do. It didn't generate, at the time period that he didn't generate substantial profits, and they had certain things they could do if they wanted to get rid of Dr. Chandra. They didn't do that.
So what was wrong with what the judge did in the judgment? I'm missing it from your argument.
Yes, on the appeal, what we say, Your Honor, is that there was a breach of contract because they terminated him in January of 2017, and at a time when they were required to continue to pay him at the same rate as Mr. O'Brien and Mr. DeCaprio. And the ground that the judge gave for that said that justified Crow Point in terminating him was that he had not generated sufficient non-legacy revenue. And what we say is that is not a ground for terminating Dr. Chandra. There was no requirement on him that he generate any non-legacy revenue. And secondly, that to the extent they wanted to get rid of him, they had to remove him as a member. That's the basis. So immediately after his termination, what they did here was they raised their salaries back up to the $300,000 level. So they terminated him in violation of the side letter, the express terms of the side letter, and then they continued to pay themselves at the $300,000 per year level. And so Dr. Chandra, as a prospective claim here, a breach of contract claim, not a wage claim, we say the termination was in breach of the express terms of the side letter, and that going forward he was entitled to get damages on account of that breach. That's the argument.
When he was terminated, wasn't he effectively removed as a member?
No, he was not. He remained as a member, and in fact, thereafter, he had to reduce his membership interest in order to get other employment, but he remained as a member. Throughout all of the relevant time period, he was a member.
So your argument basically is they should have just cut him out of the picture entirely and we wouldn't be at issue.
The argument is that they had to go through the process of doing that.
That would have been presumably the board of directors meeting, 3/4, which seems to be inferred from the fact that it's pretty clear that 3 of them didn't want him. Maybe there wasn't a vote. But
in fact, that was not the case. Phil Lucier, who was the fourth board member, never said that he was going to terminate Dr. Chandra. He was working with Dr. Chandra. There's no evidence that he would have voted to terminate Dr. Chandra at all. None of that.
Okay. Thank you. Thank you both. We'll take it under advisement. We're going to take a short break to reconstitute the panel.